Good evening, everybody, and wherever you are, you're very welcome to this evening's lecture. This is the 15th lecture in this series, but I have to start on a rather sad note, as this is the only lecture that I've not been able to attend in Hong Kong. Last year, I was at Hong Kong at HKIAC with many others, and Jan Poulsen, our lecturer that year, spoke to us from Bahrain. Let's hope that this time next year, we'll all be able to be present at HKIAC and enjoying meeting friends and colleagues, perhaps with a glass or two of wine. But of course, every cloud does have a silver lining, because even if we're not physically present at HKIAC tonight, many of you, getting on for 400, have signed up to watch this virtually. And I dare say even more will watch this in their leisure. So there's no pressure tonight on the lecturer. It's wholly appropriate that tonight's lecturer has chosen the topic of resolving financial disputes generally. Hong Kong continues to be a major financial center where many such disputes get resolved, many at HKIAC in arbitration. This topic, so important to Hong Kong, has not been discussed before, but it sits nicely with the recent Goff lecture delivered again in Hong Kong remotely the other day by the Chief Justice of Singapore, Sundaresh Menon, entitled The Complexification of Disputes in a Digital Age. Now, it's hard to think of anyone more capable of addressing this complex issue. Sir William Blair, Bill Blair, has experience as an advocate, a High Court judge, the judge in charge of the Commercial Court, the judge in charge of the Financial List, an international arbitrator post-retirement from the bench, a judge of the Qatar International Court, a deputy judge here in Hong Kong, a professor of financial law and ethics at Queen Mary University, London, and an honorary senior fellow of our generous sponsors, the British Institute of International and Comparative Law. And I have to say that I have missed out some of his other posts so as not to embarrass him further. So I now have very great pleasure in inviting Bill Blair to deliver this year's lecture.
Well, good day wherever you happen to be. And Neil, thank you for that very kind introduction. It is indeed an honor and a pleasure to give this annual Kaplan lecture of 2021. As you pointed out, last year's lecture given by Professor Jan Poulsen was also given remotely. I don't think any of us really expected at that time that we'd be in the same position as regards this pandemic as we are, not least so far as the lack of mobility is concerned, and also the absence of the kind of personal interactions that mean so much to us as human beings. In his inaugural lecture in this series, Neil Kaplan referred to the difficult problems faced at that time, the end of 2007, which of course included a gathering financial crisis. But he spoke of the continuing success of HKIAC, to which he of course has contributed a great deal personally, and which he described them as booming and popular. The same applies at the end of 2021. Whatever 2022 may hold, and we're all hoping it will be better than what we've had previously. HKIAC goes into it with a successful track record and the facilities and experience needed to function in the very different environment that we have now. I thank it for organizing this lecture, and I thank the British Institute of International and Comparative Law, and particularly Professor Spiros Maniatis, for generously sponsoring it. My subject is arbitrating financial disputes. Experience differs, of course, from country to country, and this is potentially a vast area of economic activity. My remarks are limited to the kind of disputes that arise in financings and financial products, usually in the international context and typically of higher value. There are some handy definitions, those set out in CTAC's Financial Disputes Arbitration Rules 2015, in the financial list established in the courts of England and Wales in the same year, and in the 2016 ICC Commission reports on international finance and international arbitration. It is noteworthy, though, that though comparatively recent, these definitions are already out of date. Since then, such is the pace of innovation in finance, new markets have sprung up, such as the crypto markets. Arbitration plays an important role in consumer disputes as well, but different considerations arise as regards consumer disputes, and I'm not going to deal with them on this occasion. My intent in these remarks is to address what I think are a number of key questions. The first is whether financial disputes are different from other commercial disputes, because if they are, then that affects the way that we deal with them. I shall attempt then to review how widely arbitration is used in financial disputes and where opportunities may lie for broadening its use. I will then consider some practical considerations that arise from the introduction of rules as to early determination by many arbitral institutions. A potentiality of these is to make arbitration more finance-friendly. Finally, I shall offer some personal views on what lies ahead. As someone who has sat both as a judge and an arbitrator, I want to begin by emphasizing this point, and I know that we will all agree on it. Both the courts and arbitration play an essential role in adjudicating the kind of financial disputes that I'm discussing in these remarks. As ever, courts that understand and support arbitration are the bedrock of its success, a point made by Chief Justice Andrew Chung at the Hong Kong Arbitration Week in October. Along with the increasing interest in mediation and other informal means of avoiding disputes, both the courts and arbitration strive to provide a coherent and interconnected system of dispute resolution. This is much needed. Finance in all its forms is a formidable force in our world, for good, and unfortunately, sometimes for not so good. In dispute resolution, there are sometimes delicate balances to be made in upholding the parties' contractual relationships, whilst recognizing the overarching importance of financial stability and the public interest. So, are financial disputes any different from other disputes in the commercial sphere? In some respects, plainly not. Financial contracts are, in principle, no different from other commercial contracts, and interpreting and applying them requires no special expertise beyond what is required for commercial disputes generally. Yet, a point that has been made on many occasions is that the operation of particular financial markets can be very technical, and an understanding of how they work and the applicable rules can be very useful for decision makers who are otherwise dependent on expert evidence of varying quality. Professor George Afaki has recently drawn attention to the potential impact of financial regulation on disputes. Most financial institutions and markets are regulated to a high degree. In fact, they are among the most highly regulated businesses in the world. Lessons were learned the hard way in the global financial crisis, which nearly brought the whole system down. As Professor Otc pointed out, in deciding financial disputes, regulatory compliance may need to be taken into account in a number of ways, including potential breaches of contract. Much of what is happening in finance today is taking place in the form of fintech. This is one of the most active areas in the whole tech field. There is a constant drive for innovation with digital technologies. We are in the early stages of a transformation. Tech companies such as Facebook, now Meta, aspire to be players in the finance space, as indeed tech companies have in China for at least 2 decades. Central banks are considering, and in some cases, such as the People's Bank of China, already issuing their own currency in digital form. This is not somehow restricted to a small group of countries. Last October, Nigeria launched its own central bank-backed digital currency called the e-Naira. At the international level, there has been fierce competition for the title of global fintech hub. Yet, what has been to date the light touch regulation of the fintech space seems to be coming to an end, a well-publicized end in China, but in many other countries also. How have the courts and arbitration reacted to these changes? So far, developments are valuable but relatively limited. In China, specialist rules have been issued, for example, by CTAC and the Shenzhen Court of International Arbitration. HKIAC's panel of arbitrators for financial services was set up in 2018, the same year as the specialist financial court was established in Shanghai. Outside China, examples are the establishment of prime finance in The Hague and the specialist financial list in the English courts. Experts are always in heavy demand in the more specialist areas of financial disputes, and it is not always easy for parties to find them. As Chief Justice Sundaresh Menon of Singapore put it in his Goff lecture in November, our increasing reliance on expert witnesses is a sure sign of the technical complexification of disputes. Our increasing reliance is a problem in which he gave far-reaching insights. As to who actually has this expertise, Prime has a panel of financial experts who are evaluated by a selection committee before they go on the list. The American Arbitration Association also maintains a national roster of arbitrators for commercial and financial disputes, but this is not publicly available. Lastly, I mention another hot topic, which is free trade agreements. A number of the FTAs the UK is currently negotiating contain provisions for a specialized roster of arbitrators for disputes relating to financial services because of the economic importance of these. But of course, these specialized resources join the wealth of financial and commercial expertise already existing in the courts and arbitral tribunals of many countries. Technology is a recurrent theme, and over time, it's bound to have a profound effect on the resolution of financial disputes. The COVID-19 pandemic has accelerated the move to a digital world already. This will involve much more fundamental rethinking than seen to date. In April 2021, the UK Jurisdiction Task Force published its digital dispute resolution rules to be used to facilitate the resolution of commercial disputes in this field. The rules allow for arbitral or expert resolution in very short periods, for arbitrators to implement decisions directly on chain, using a private key, and for optional anonymity of the parties. These rules may be particularly useful for parties that have ongoing dealings in the digital markets and are mutually concerned to see the swift resolution of disputes. The use of these rules and other rules that will surely come will not only encourage but require a high degree of sophistication from the practitioners, arbitrators, and adjudicators of the future. Young practitioners in arbitration from countries around the world are very well placed to provide this expertise. So, how widely is arbitration used in financial disputes? There's an oft repeated proposition in international arbitration that historically financial institutions have used the courts for resolving their disputes, but that the use of arbitration is growing. To make clear at the beginning, this does not necessarily apply to domestic arbitration. The Shanghai International Arbitration Center has quoted data released by the Ministry of Justice showing that about 500,000 arbitration cases were accepted by 255 Chinese arbitration institutions in 2018. And of these, roughly 22.1% were financial disputes. But internationally, the 2016 ICC Commission report conducted an extensive consultation, and it concluded that generally financial institutions do expect to litigate their disputes in court rather than arbitrate. The report also emphasizes that there is little opposition to and the recognition of considerable potential for arbitration. A project at the University of Cologne on arbitration in banking and finance, chaired by Professor Klaus-Peter Berger, a long-standing advocate of arbitration, considers that such disputes require both industry-specific know-how and specialized legal knowledge. In any case, the project is well placed to provide evidence of trends. One reason for this may be historical. Today's financial markets, revolutionized by information technology from the 1960s on, never had the tradition of arbitration, which was developed in international trade. Another more prosaic reason is customer satisfaction. Courts in the major financial centers are seen by financial actors as reliable and predictable, a point made by Inka Hanefeld in writing on this subject. The overall picture, though, makes clear the widespread use of arbitration in particular contexts, such as emerging markets, and there is evidence that backs this up. For example, in 2020, the banking and financial services sectors accounted for 13.5% of HKIAC registered cases and 20% of those of the LCIA. Further, and this is an important point, the number of arbitrations that make it into the statistics does not necessarily reflect the frequency of use of arbitration clauses. In December 2020, after considerable reflection, the Beijing-based Asian Infrastructure Investment Bank issued general conditions for sovereign-backed loans. These provide for arbitration in accordance with the UNCITRAL arbitration rules. However, speaking in Hong Kong, Mr. Jared Sanders, then the General Counsel of AIIB, explained that these disputes are rarely, if ever, resolved through formal adjudicative processes. The problem is almost invariably an economic and political one. The OTC derivatives market is another case in point. The vast majority of cross-border OTC derivatives transactions are governed by the terms of the master agreements published by ISDA. The standard terms of ISDA master agreements, which have generally provided for disputes to go to the courts of New York and London, have since 2013 had an arbitration option, which in 2018 was expanded to include a larger number of institutions and seats. Although anecdotally, it seems that use of arbitration is more a feature of emerging markets, the fact that the option is now available is significant in itself. Financial institutions are, of course, sophisticated users of legal services and will use arbitration when it suits them to do so. In project finance, hybrid clauses are common, which include the courts of the host country where the project is physically situated, commercial arbitration clauses, and potentially giving the courts of leading financial centers jurisdiction under the financing documents. I understand that in M&A transactions transacted in Hong Kong, arbitration is part of the course. Now, I turn now to the introduction of new rules in arbitral institutions. As a matter of background, in 2018, the International Arbitration Survey carried out by the School of International Arbitration at Queen Mary University of London and White and Case found that expedited procedures for claims and summary determination procedures were considered the most favored improvements and innovations to arbitration procedure for the banking and finance industry. The same point had been made by the 2016 ICC Commission. Since then, a number of arbitral institutions have successfully introduced expedited procedures, particularly for lower value claims. This is a very useful development. But since the subject of these remarks is higher value claims, I will concentrate on the other objection, the absence in arbitration of summary determination procedures, such as those available in the courts of common law jurisdictions, including, of course, those of Hong Kong. Starting with SIAC in 2016, there have been notable developments in this area, with the introduction into institutional rules of early determination provisions. In my view, this is significant, but it does raise some fundamental issues. These have been discussed for some years by leading arbitration practitioners, and I pay respectful tribute to their analyses. Let me begin with some personal experience. In the United States, Section 15B of the 2000 Revised Uniform Arbitration Act provides that, quotes, an arbitrator may decide a request for summary disposition of a claim or particular issue. There is no comparable provision in English law, but in a case called Travis Cole Restructured Holdings and SR Global Fund, the holder of an ICC award seated in New York was seeking to enforce it in the UK. Enforcement was challenged on the grounds that the tribunal had adopted a summary process. The claim involved a case under a guarantee, so it was a financial case. The tribunal had dismissed certain fraud-based defenses, adopting a procedure that fell short of a full hearing on the merits. The respondents objected to enforcement on this ground, but this was rejected by the court, partly on the basis that the arbitration agreement terms were wide enough to cover the course taken by the tribunal, but also because the respondent's submission that a summary process by arbitrators necessarily amounted to a denial of due process was wrong. This conclusion is in accordance with a line of decisions by courts in the United States. But it has to be admitted that the term summary can grate on the ears because it has connotations of summary justice in a pejorative sense, whereas the reality is that in an appropriate case, these provisions provide rather than deny due process. But this may explain why, in changing their rules, many arbitration institutions have tended to avoid the term summary and refer to early determination or early disposition, which seems a better fit with practice in the international arbitration context. Whatever it is called, the significance of this to FIs, that is, financial institutions, should not be underestimated. It's of course true that in dispute terms, there may be no real comparison between a simple claim for repayment under, say, a loan agreement and a more complicated claim under a complex financial product. Still, financial institutions tend to approach many of their claims on the basis that they are founded on clear counterparty liability, save perhaps for quantification after closeouts and the like, but certainly nothing that would justify a full merits hearing. To state the obvious, a default is not the equivalent of a dispute. It should also be borne in mind that although the power to dismiss meritless claims is significant, and much of the discussion of this topic has to do with meritless claims, the more significant power from the perspective of FIs is the power to dismiss meritless defenses and so enable the case to proceed to an early resolution. This can be important in a number of contexts, including the realization of security. But the benefits of early determination, where appropriate, are certainly not limited to FIs, but apply equally to their counterparties from outside the financial sector. Where the counterparty has a strong claim against a financial institution, it should not be held up. Likewise, if it has a valid defense, it should not be disadvantaged by the omission of a full merits hearing. These points are not limited to finance in any way. The reason for early determination rules is to save time and expense and so seek to address a pervasive criticism of contemporary commercial arbitration, but only where this is justified by the case in question. It is true that this requires earlier consideration of the issues than would otherwise happen, but the advantage of arbitration is its flexibility when it comes to procedure. The changes introduced by arbitral institutions have been summarized in an article by David L. Wallach, which has recently been published in Arbitration International. He points out that early disposition rules vary significantly in scope and content, and many rules, both institutional and non-institutional, have not yet adopted them. That is true, but an impressive cohort of institutions have adopted them, including, roughly in chronological order, SIAC, JAMS, SCC, that's the Stockholm Institute, HKIAC, LCIA, ICC, the latter by way of a note issued on the 1st of January 2021, and ICDR. To these should be added the investment arbitration rules issued by CTAC and the Beijing Arbitration Commission, and the revised prime finance arbitration rules, which come into force on the 1st of January 2022. Yet, it seems clear from the available evidence that so far, the actual application by tribunals of such procedures is very much the exception in international arbitration. Whilst there are weighty reasons for this, in suitable cases, there are a number of reasons that go the other way. First, these rules having been adopted, they are going to be used and indeed are being used. Second, the possibility of early resolution encourages early settlement, which is just as important in finance as in other fields. Third, if conventional procedures cannot provide expedition, then the trend in finance is towards more radical change, as in fintech. See the 2021 digital dispute resolution rules I've already referred to. Fourth, the effects of the ongoing pandemic do seem set to change many aspects of arbitral procedures in the long run. Ultimately, of course, the markets will decide. But the practical issues that distinguished and experienced arbitrators and practitioners perceive with such procedures are real and need to be addressed. I shall now seek to address a number of them that seem to be the most important ones. A prior question is as to scope. In other words, what are the parameters of a tribunal's powers of early disposition? Subject to the terms of the arbitration agreement, this depends, of course, on the scope of the institutional rules. There seems, however, no reason of substance why, at least in commercial arbitration, they should not cover the same ground, but the rules do differ and clearly need to be carefully applied in every case. But to keep the present discussion within bounds, I shall make an assumption and treat the institutional rules as broadly covering claims and defenses and individual issues of fact and law arising therein. There are exceptions, such as ICSID Rule 41.5, which is limited to claims, but this is perhaps understandable in the investor-state arbitration context. So the first question is, when does a request or application for early disposition have to be made? The ICSID rules prescribe that it has to be made at the outset of the arbitration, but institutional rules seem generally to be relatively unspecific in this respect. This contrasts with the rules of court in common law jurisdictions, at least those jurisdictions with which I'm familiar. For example, an application for summary judgment could be made as soon as the defendant joins the proceedings, for example, by giving notice to defend the action. A claimant can thus frame the proceedings at the outset as fit for early determination. This works in practice because, as we all know, most disputes begin with lengthy exchanges between lawyers. The parties go into the proceedings knowing perfectly well what the issues are likely to be. In arbitration, likewise, it seems reasonable for tribunals to expect a request by a party for early determination to be made at the earliest point that it can be made. Otherwise, there will not be the saving in time and costs that this procedure is intended to achieve. Second, what procedure applies to the making of an application? This is again an important question, and again, it varies, with some rules providing an outline procedure with or without time periods, and others, such as the LCIA in its 2020 rules, leaving it largely to the parties and to the tribunal. The SIAC rules make clear that the applicant must provide a detailed statement of the facts and legal arguments supporting the application. The responding party then has an opportunity to respond. The timeframes within the SIAC and HKIAC rules for the tribunal to make a decision on the request and issue an award if the application is accepted are important, and in practice, in cases of any complexity, an extension may well be needed. But subject to the applicable rules and what, if anything, is set in the arbitration agreement, it seems generally to be for the tribunal to adopt a procedure. This requires considerable thought because there is always the risk that weak applications are made for strategic reasons, bogging down the whole arbitration. For this reason, some institutional rules expressly provide for a process by which the tribunal first reaches a preliminary decision on whether to allow the application to proceed. If it does, then it goes on to decide the outcome of the application after further submissions and potentially a hearing. This is different from court procedures, under which a party has a right to proceed with a summary judgment application. But it seems sensible in the arbitration context, since if the tribunal feels, having received a request, that it is unlikely to go down that road, time will not be taken up on the application. Even where this is not explicitly provided for in institution rules, there is no reason why a tribunal should not adopt this course. Because of the depth of experience in the United States in dealing with such procedures, it's illuminating to see how this issue is dealt with in Article 23.1 of AAA's 2021 ICDR International Dispute Resolution Procedures. Under this rule, a party has to seek the tribunal's permission to submit an application for early disposition. Permission will be given if the tribunal determines that, first, the application has a reasonable possibility of succeeding. Second, it will dispose of or narrow one or more issues in the case. And third, that consideration of the application is likely to be more efficient or economical than leaving the issue to be determined with the merits. These are useful criteria under any rules. Making a formal determination at a preliminary stage as to whether or not the application has a reasonable possibility of succeeding, however, seems to be tricky and unnecessary. And indeed, reading the rest of the rule, this does not seem to be required. The tribunal's role at this stage is only that of gatekeeper. It is deciding whether allowing the application to go ahead is the efficient course, or whether time and resources are better spent in allowing the matter to proceed to a merits hearing. That brings me to the critical question, that is the threshold test. The experience of the common law and other courts can offer insights, but the test is an international one. However, it is fair to say that whether in court or in arbitration, deciding these issues necessarily involves questions of judgment dependent on the facts and the applicable law and the overall shape of the case. However, the most important point is that this procedure is only for clear cases. In the ISDS context, the text for early dismissal under ICSID Rule 41.5 is that the claim in question is, quotes, manifestly without legal merit. This use of the word manifestly has been stated by tribunals as requiring the applying party, again I'm quoting, to establish its objection clearly and obviously with relative ease and dispatch. The standard is thus set high, close quotes. The test, as stated, does, however, go on to make it clear that the mere fact that the issues are complicated is no bar. This is an important consideration in financial cases. The import of it is that a reasonable investigation to determine the weight of the issues is in order, but it should not be so lengthy as to amount to a merits hearing in all but name, but without the rights that parties have at such a hearing. Since the word manifestly is commonly found in institutional rules, this test is likely to be persuasive. In courts of common law jurisdictions, if summary judgment is not granted, it is standard practice to give directions after considering the application. This may be a good course for a tribunal as well. If it is the view of the tribunal that the applicant's case is substantial, but not quite up to the requisite standard, the opportunity is there to consider whether to apply expedition. Crucially, the making of the application may give the tribunal a better understanding of the issues than it may often have at the time of the first procedural meeting. Many other points will occur to arbitral practitioners. These will be worked out by tribunals over time. But given that in 2021 alone, at least 3 arbitral tribunals have introduced early disposition provisions, there should be ample opportunity to do so. Confidence on the part of FIs that procedures that allow for rapid adjudication of what the 2016 ICC Commission described as open and shut cases are, as anticipated in its report, an effective way of attracting financial claims that would otherwise not come to arbitration. So what may lie ahead? It's difficult at the best of times to predict even the near future, and the midst of a pandemic is, to adapt Charles Dickens' famous phrase, the worst of times. I've discussed the centrality of fintech already, and there are 3 other points that I would venture to mention that seem to be relevant to financial disputes and how we resolve them. The first goes to encouraging conciliation at an early stage, allowing commercial life to continue. This is not unique to finance, of course, but it is important to highlight it, particularly in a pandemic. We are working on this in Bickle's Breathing Space project and have produced guidelines on how to encourage a conciliatory approach, trying to avoid or minimize legal proceedings without altering the parties' legal rights should conciliation fail. The second is about the role of arbitration in China's vast financial sector. Because the sector is so big, it seems probable that an increasing number of disputes will require formal adjudication, which in turn will lead to the development of the law. The role of the law was emphasized in remarks given by Governor Yi Gang of the People's Bank of China at the 2021 G30 International Banking Seminar in the context of the problems of Evergrande, which have been much publicized, of course, and which he said would be dealt with in strict accordance with the law. The probable increase in the role of adjudication takes place against the background of proposed reforms to China's arbitration law, which many listening will be very familiar with, including a proposal which may open its market to foreign arbitration institutions. There is a further important practical point to make. In any arbitration, resolving disputes effectively can be thwarted by the perennial problem of assets disappearing in advance. For financial institutions, as with other claimants, the availability of interim relief, whereby assets are preserved, is potentially a game changer. Here, Hong Kong has an advantage as the only arbitration venue outside of mainland China, where parties to arbitration may obtain interim relief from the courts there. The mutual assistance arrangement in court-ordered interim measures in aid of arbitration proceedings was concluded in 2019. As of 18 November 2021, according to statistics HKIAC has provided, the institution has assisted in 56 applications by way of a letter of acceptance. 53 applications were made for the preservation of assets, 2 were for the preservation of evidence, and 1 was for the preservation of conduct. I understand that so far as HKIAC is aware, there have been 40 decisions of the mainland courts, of which 37 granted interim relief in sums totaling 12.4 billion RMB, approximately 1.9 billion US dollars. So I come to close now, and I'm happy to do so with this third point. It is about the growing need for sustainable finance. As regards climate change, the United Nations has describe climate finance for both mitigation and adaptation to climate change as a key pillar to achieve the goals of the Paris Agreement. This has long-term implications for the incidence and resolution of financial disputes, as was noted in a 2019 ICC report on resolving climate change-related disputes through arbitration and ADR. In advocating early resolution, the report points out that climate change action is universally acknowledged to be urgent. Arbitration of climate change-related disputes must be able meaningfully to accommodate that urgency. Sustainability is on everyone's minds, and rightly so. And in the conduct of arbitrations, the campaign for greener arbitrations has had an impressive uptake of the Green Pledge. As an increasing number of arbitration practitioners sign up to it, it would be good to think that we can all make a difference. Thank you for listening to my remarks.
Neil, you're muted.
Right. Okay. Bill, thank you very much for that. Can you hear me now? That was an excellent lecture, very fascinating points. And there is an opportunity for anyone to ask a question if they type it in, and then I can read it and put it to you. But until they do so, let me ask you a few questions, if I may. You spoke about financial parties, in a sense, being more inclined to go to court than to arbitration. You discussed that point. Do you think they would be more inclined to go to arbitration if there was a possibility of an opt-in appeals procedure within the arbitration, so that the very rare rogue decision could be corrected by an appeal tribunal?
Well, let me perhaps refer back to the position in the UK, where there is a limited right of appeal to the courts, though. I think you've got in mind the right of appeal to a particular specialized arbitration tribunal, though. I think we see that to a very limited extent in ICSID. I doubt personally that it would prove to be a great attraction. And the reason is that I think that the really important thing for international commercial arbitration, and where it has been actually very successful, is in terms of credibility. Arbitral decisions, of course, are often very controversial, and the losing party dislikes losing. There's no getting around that fact. But there is, I think, an inherent credibility that international arbitration has attracted over 30, 40 years. You've been an important part of that, Neil, if I may say so. And so personally, I think the award should be the end of the road. I can see why it's different in ICSID, although the number of occasions on which the awards are not upheld is tiny, I think. But no, I don't really think it would be an attraction to international financial institutions or the finance sector generally. As I said, I think the thing that would count for them would be confidence on two fronts. One, that the decision of the arbitral tribunal was at least sensitive to whatever the particular financial market might be, and secondly, that it would be produced quickly.
Okay. You talked about summary disposition, and that's a very important topic, as you say. Do you think it's necessary for these rules to be underpinned by legislation in the arbitration acts around the world to make it clear that this is part of the law and this is not something that can be dealt with by due process allegations later, as the case with Bill Park showed?
Well, as I pointed out, the US does have a specific provision of law to that effect. I'm not aware of any others. You may be. I tend to think not. I think that you see, really the the true approach to this, and I know it's a difficult topic for many arbitrators who, and you can see that in terms of the very limited uptake so far. But I think the true way of looking at this is not so much that it's a summary procedure, but it's a fair procedure in the particular case. As I put it in my remarks, it's providing due process, not denying it. So I think to have a bucket called summary is not actually particularly helpful.
Does the word manifest cause more trouble than it solves?
Well, you have to have a test, yes. And the word manifest, I think, captures it. I don't think the word manifest causes any particular problems. You're always going to have an issue applying any test. By definition, it's going to be a question of judgment. But I mean, if you look at common law courts around the world, they define the test in all kinds of different ways, and they change the test from time to time. But actually, the basic ideas always remain the same.
You mentioned, but didn't deal with it at any great length for reasons you gave, with expedited hearings. I just wonder whether we've got expedited hearings wrong way around. Shouldn't all hearings be expedited with the right of the parties to opt out of expedition for a longer period, a slower arbitration, for which they can themselves take the blame rather than blame it on the arbitrators and the institution?
Yes, I mean, you're absolutely right. I mean, the arbitration rules require the thing typically to be dealt with by including expedition. So, in a sense, expedition is already built into the DNA of the arbitration process, and it's certainly not some kind of add-on. But I think my understanding, by the way, with the HKIAC is that their expedited procedure has been very popular. I think it's worked well, and I think that the same probably applies to others as well. And there is I think this advantage in the monetary limit, which of course the parties don't have to accept, but having a monetary limit, I think, is a good idea because it gives the thing a nudge in the right direction. You may not be required to do it, but it means that there's at least no debate between the parties as to whether, or at least in many cases, no debate between the parties as to whether the monetary limit applies or not.
We have received a question from Saif Al-Khamis. How do you see class action in the UK as procedural role in addressing financial securities mass claims?
Well, I think that's a very important question, and thank you for it. The class actions addressing securities claims, of course, have their genesis in the United States. In the UK and in Europe generally, because the UK and the European Union really, I think, have been proceeding roughly down the same road. There has been now in the last 5-6 years much more willingness to allow class actions, and in the financial field, we've seen it with credit card charges, which is a very large issue, and there are many billions of dollars and euros at stake. But it doesn't really work for arbitration, because you don't have the same. You don't have an arbitration agreement that covers it. That would be my response.
Okay. John Taylor has asked, would increased transparency of arbitral awards help to build increased credibility?
Well, I think that's another good question, and it's certainly helped, I think, a lot in investor-state disputes, where you can see what has happened. This is a debate that's been going on for so long. I think I just simply answer it by saying that I think the trend is towards more transparency, but I don't think that really the arbitral community is yet fully ready for it.
When you talk about transparency, I mean, you mean more sanitized awards being published?
That kind of thing.
Yes. I'm told there are more questions in the Q&A section.
Oh, I see there was a question from Michael Wang, which I think if you could pick that out.
Yes. My experience is that commercial banks don't like arbitration because it doesn't serve banks well for purposes of debt collection, which is where most banks have to engage in disputes with their customers. And this is because arbitration has not, until what Sir William has described in his lecture, had any equivalent of summary judgment, which is bread and butter to all commercial bank lawyers. But where banks have disputes with other banks in their commercial deals, then they're more likely to use arbitration litigation, because in such cases, confidentiality is important and speed is not the greatest criterion. Would Sir William comment on my observations from his experience?
Well, certainly that's true, and I can think of an arbitration involving the sale of bank branches, for example, where the two banks concerned were keen on confidentiality. So I mean, Michael Wang is one of the world's most experienced arbitrators, and for what it's worth, I agree with what he says. It's always difficult to know by definition exactly what is happening when what is happening is not public, because the parties don't want it to be public. But broadly, I agree with what he said.
I don't know whether you can help on this one. Samantha Mathieu has followed this lecture from Germany, and she asks, may I understand better on how to raise awareness and acceptance to choose traditional arbitration? How can we bind in mediation further?
Well, again, I think that's a very, very important question. I think the Singapore Mediation Convention shows how the wind is blowing. I mentioned the work that we've been doing at BICL in relation to conciliation. I mean, you don't actually have to really wait for a formal mediation. You can you can encourage parties to conciliate and provide an environment which helps them to conciliate. Now, as to actually binding in mediation, again, the Med-Arb debate. I think I heard another arbitrator saying recently that that debate seemed to be going on for as long as he could remember, and he wasn't a young arbitrator. But it doesn't really seem to have kind of got anywhere in particular. We're all familiar with the difficulties. It's difficult for arbitrators to express views too clearly too early anyway. But I haven't got a good answer to your question. I've got a bad answer to your question, which is that I firmly believe that we cannot continue, particularly in a worldwide pandemic that has caused such a lot of distress, by simply proceeding on the basis of business as usual. I do not think that will work so far as disputes are concerned. How you build in mediation and so forth, we just simply have to keep working at it, I think.
I don't know whether you've tried in your arbitrations to build in a mediation pause in the procedure. So there's a 6-week period where nothing happens and the parties know that that's the time when they can use mediation services if they want to do so, without anyone being under any sort of pressure or feeling weakness in doing so. But they're told at the beginning that there's this pause for that purpose if they want to use it. If they don't, no matter to the tribunal. I think that's not a bad idea, but what do you think?
Well, I think it's a good idea. I mean, the only point I'd add from my court experience is that in court proceedings, it's quite common for mediations to take place, but it doesn't actually affect the procedural timetable in any way. And that I think can also work. So the pause I can see is a good idea, but also in some cases it's a good idea for the procedural timetable to be on it anyway. And it does put some pressure, I think, Neil, on the parties. Actually, if they're going to agree their dispute at the end of the day, and you know, most disputes end in agreement, the vast majority. If they're going to agree at the end of the day, it's a good idea to agree before they start spending, for example, large amounts of money on expert reports.
Right. Well, I think I'm going to hand over now to Spiros, who's going to say a few things and something about Bickle. Over to you, Spiros.
Neil, thank you. Sir William, thank you for a brilliant lecture. I also want to thank the Hong Kong International Arbitration Center for working so closely, developing the theme for the Kaplan lectures. I'm delighted we are working with Neil and the Hong Kong International Arbitration Center in this area. And this series of lectures has become almost like an encore for Bickle in Hong Kong. The only thing I want to mention is special thanks to Emily Poon for working so diligently and keeping track of what is going on and helping us all. And she was really the force behind the lecture, apart from the lecture itself. I also want to make 2 advance notices, if you like. I do hope that next year we will be there in Hong Kong, and Neil, Sir William, and I'm sure will join you for drinks after the lecture. I hope that things will be better in 2022. And I also want to mention that at some point in the spring of 2022, Bickle will be launching a forum on innovation in dispute resolution that will be looking at the substance, but also the procedure in arbitration. We will try and cover big themes like cultures of dispute resolution. We will try and cover themes like green arbitration, sustainability, diversity. That is a point that has been raised as part of the question answer session today, and transparency as well. So grateful to Sir William for the lecture. I'm delighted that we're working together, Neil. Looking forward to next year, seeing you all in Hong Kong, and thank you for joining from all over the world. Grateful, thank you.
Thank you very much.
Thank you, Spiros, and thank you very much indeed. And good night to everybody. And I look forward to seeing you next year in person. Bye-bye.